Today on Law Weekly, some lawyers share their thoughts on the transition program, especially against the background of arguments in some quarters that the country needs a constitutional template for the handover. On our interview segment, business lawyer Ayuli Jemide speaks to Law Weekly about the ease of doing business in Nigeria and how lawyers will engage key regulators in the country with a view to improving the country's ease of doing business ranking. All that and more on this episode of Law Weekly on Channels Television. Hello and welcome, I am Shola Shuyeli. Let's begin straight away with some reactions to the arguments in some quarters that the country needs a constitutional template for the transition program, when there appeared to be friction between the committee of the outgoing and incoming administration. Some Nigerians felt that a constitutional provision would have spelled out what should guide the process both at the federal and state levels. But what do lawyers think?
There's obviously a gap. The problem we are having with the ruling party and the exiting party saying that there's a problem with respect to transition or no transition. That should have been taken care of by the Constitution. There should be an express provision in the Constitution as to what should happen when a government is handing over to another government. You understand what I'm saying? There should be, in my mind, there should be a transition committee immediately after an election, probably a week after that election. The government should step down and hand over to a transition committee that will midwife the transition to an incoming government. There won't be a problem if it is the ruling party that wins the election. Then there won't be any problem to that effect. But a situation where an opposition party wins an election, the party in power should step down immediately and hand over to a transition committee. You understand? If there's such a provision, there won't be any need for this furor on whether there's a cooperation from the incoming government, between the incoming government and the outgoing government.
I really don't feel there's a lacuna anywhere. There are provisions concerning all these items. I believe it has to do with the antecedents and the fact that this is happening for the first time maybe, I won't say in a long time, this is happening for the first time ever. Apart from that, if a party is going out and another party is coming in, there's bound to be differences and all of that. But whatever it is, I think it has to do with the will, the maturity, and the commitment of those that are in there. All this noise we're talking about, there isn't anything major. There's bound to be cries from this side, hues from this side. But at the end of the day, the whole thing will come out fine. I can assure you, the president gave in some few days before, some few hours before it was announced, and at the end of the day, it made it easier for Nigerians. The same way, I believe, handing over will be 28th, and then the ceremony will be 29th. There isn't anything like a lacuna in there. There are provisions, and I believe that like any law in the world, it takes the people and the commitment to making it work. That is just it. Outside that, there isn't anything that gives room for a new laws being made or new provisions being put in place.
I would imagine that the maturity and the sincerity of purpose can effectively define and take care of this transition. And what are the issues? It will be too late in the day to think that anything can be hidden under the carpet. As a matter of fact, it should go out there to them as a note of warning that it were better to present the facts as they are other than trying to circumvent them. The reason being that the more of that you do, the more possibility that you are lending credence to the fears of the incoming government. I have made the point that it is not supposed and it cannot be a constitutional issue, lest we will be bogged down.
It is very key in the democratic history of Nigeria. This is the first time since we moved into a democratic regime when the current government that has been in power for 16 years will be handing over to the opposition. And so it is very key. The country will be a cynosure of the world as far as our forthcoming inauguration is concerned. But having said that, it means that we should anticipate some flaws. It's a fledgling process, and to that extent, it may not be very smooth. All I advise is that politicians should always tread with caution, bearing in mind that the collective will of all of us supersedes that of every politician.
There are interesting times ahead, especially with the signing into law of the Administration of Criminal Justice Bill. That and more in this recap of some of the top legal stories that we tracked.
We begin with the good news that President Goodluck Jonathan last week Wednesday signed the Administration of Criminal Justice Bill 2015 into law. The bill, which was passed by the Senate on May 5th, 6 to, among other things, address the problem of delayed criminal trials.
Excellency, the President of the Federal Republic of Nigeria.
Special Advisor to the President on Media and Publicity, Dr. Ruben Abati, confirmed that the bill was signed into law the same day the President received it from the National Assembly. And the Chief Judge of Nigeria, Justice Mahmood Mohammed, last week Thursday, hinted that the National Judicial Council, the NJC, will henceforth advertise to fill vacancies for judges. Advertising to fill vacancies for judicial officers is one of the new measures contained in the 2014 revised NJC guidelines and procedural rules for the appointment of judicial officers of all superior courts of record in Nigeria. The guidelines are aimed at providing for a more comprehensive, robust, and transparent method of appointment, leading to the emergence of only the best legal minds with high moral standards to serve as judges. Acts of lobbying for appointment, exhibition of bad behavior in and out of court, influence peddling, rendering dishonest or questionable legal opinions, submission of false credentials are some of the conducts exhaustively listed in the 2014 guidelines as acts that would preclude appointment to judicial office. To the courtrooms now. The long arm of the law last week Tuesday caught up with 4 men accused by the federal government of stealing petroleum products belonging to the Nigerian National Petroleum Corporation (NNPC), as a federal high court in Lagos convicted and sentenced each of them to 9 years imprisonment. According to the government, the 4 convicts conspired to damage oil pipelines and stole 33,000 liters of premium motor spirit valued at approximately 3.2 million naira belonging to the NNPC on July 13 along the Ekpe-Ikorodu Road in Lagos. They were apprehended while trying to sell the stolen products to filling stations in Lagos. Trial Judge Justice Okon Abang also ordered that the petrol stations that brought the stolen products should make restitution of the sum of 3.2 million naira to the federal government within 7 days of the judgment. While one court was jailing all pipeline vandals, the Economic and Financial Crimes Commission, EFCC, was on the same day rearraigning suspected oil subsidy fraudsters before another court. Maman Ali, the son of the former chairman of the People's Democratic Party, Ahmadu Ali, and 2 others were rearraigned in Lagos for their alleged roles in a 4.5 billion naira fuel subsidy support fund. The 3 were rearranged after one of the suspects allegedly absconded. The 49-count charge indicates that the suspects were alleged to have conspired, obtained money by false pretenses, forgery, and use of false documents. According to the EFCC, the defendants fraudulently obtained the funds from the federal government between January 2011 and April 2012. And we round off with the news that a federal high court sitting in Abuja last week Monday ordered that prosecution witnesses in the trial of Aminu Oguche, the alleged mastermind of the Yanya bombing, can be shielded from public view with the use of tinted screens. The court's order followed an application by the prosecution on the need to protect the identity of the witnesses. Justice Ahmed Mohammed, in his ruling, said only the lead counsel to the accused persons would be allowed to view the facial identities of the prosecution witnesses. The court also granted the request that the protected prosecution witnesses get access to the courtroom through a non-public route.